Welcome, everybody. And it was in all of which she said, and I, you know, his wife there. Oh, well, I never got say no. Say no. Well, no idea. I'll just look at y'all. Get it? No, no, they. So right, all the. All over. We might not have to get it until everybody points down. Just now.
Professor, when you're ready. We're ready. Go ahead. Yeah.
Good afternoon.
Good afternoon.
Glad to see you. My name is Potts Reilly, and I am a instructor at Texas Tech University, political science classes, among other things. I'm also a lawyer in practice, private practice, and I am also the judge of the Granite Shoals Municipal Court of Record. We've been out the Granite Shoals area on Lake LBJ. And it's kind of fun to talk about the Supreme Court because it's one of those things you don't do a whole lot about in the press, except when they have a big decision or you got an appointment coming up or something like that. Other than that, you generally don't hear much about it. So what today I'm going to do is going to give you have a quick background of the court, how the justices get there, talk about the justices' backgrounds, their judicial philosophies, and how they align with other justices. about the impact of oral arguments on the decision-making process. What goes on to a degree, as we know, goes on behind the closed doors in the conference rooms of the Supreme Court. And then maybe the effects of the leak of the Dobbs and Fortune case, and I'll talk a little bit about a few of the cases pending before the court is turned. So, by the way, it is really kind of an honor for me today. I've got one of my teachers originally, Patty Huntley, here. We joke, she taught me everything I know except maybe about the Supreme Court. And Sarah Ramos is one of my students, so one of my former students. So I see I got a colleague out there, Dr. Nancy Allen, out in video land. So anyway.
No, I can't either.
We're working on it. Sorry, y'all.
Criminal activity or some other activity or that. We've only had one Supreme Court justice impeached, and that was many, many years ago. They have no term limits. There are actually no qualifications for the court. Oddly enough, they don't have to be lawyers. They don't have to have been judges or anything like that. But in today's terms, the court being the highest part of that judicial branch of the government, the senators who make the confirmations and the presidents who make the nominations going to insist that they be lawyers, they be judges. They've had people on there before that haven't even gone to law school, but the last one of those was Jimmy Burns, who was appointed by President Roosevelt back in the 1930s. But everyone else since then has been a law school graduate of some sort. Got a few judges, Justice Elena Kagan, for example, who's on the court, who have never had any judicial experience, but she was a very well practiced practitioner. She argued cases before the Supreme Court, knew how the process worked and everything else, and had a pretty good public record before she got there. Today, the judges, and taking those, is a months-long process. By the time the president makes a nomination, it takes a long time for them to actually get on the court itself. Yes, sir.
Pause you for
You may.
one quick second.
Absolutely.
Sorry, everyone. Just don't want to mess yours up. Go ahead.
Okay. All right, carrying on. Today it takes months typically from the time a person is nominated until they get there. President Washington's nominations got to the Senate on one day and they were approved the next day. But they're a little bit more controversial today than they were then. And the very first nominee, it doesn't seem like it was that long ago, who actually went before the Senate and sat down and testified. You see them all do that today. Was Abe Fortas, who President Johnson, he was sitting on the court already. Earl Warren, who was the Chief Justice of the Supreme Court, President Eisenhower appointed, was retiring at the end of President Johnson's career. And so Johnson nominated Fortas, who was already on the court, to become Chief Justice. The court was becoming more and more of a lightning rod by that time, from the cases from the 1950s involving civil rights cases and into the 1960s with the continued civil rights issues. It was sort of a kind of reaching a boiling point, if you will. The Southern Democrats didn't want conservatives on the court. And so there was concern about Justice Fortas. By the way, his background was he was a lawyer. He had practiced before the Supreme Court, argued some of the biggest cases there, Gideon versus Wainwright, which is the case that where the Supreme Court said that a person who doesn't have the funds to hire a lawyer, and if their liberty is in jeopardy, they're about to go to jail or go through capital punishment or something like that, the government has to provide them with a lawyer. Anyway, he argued that case. But he was also President Johnson's lawyer in a 1948 case, which was the case that got him to become president of the United States, ultimately, because it was a case in which President Johnson, who at the time was a member of Congress, and Coke Stevenson, who was a governor of the state of Texas, had run against each other. Stevenson being the more conservative one, Johnson being the more liberal one. We got like Amber Alerts going on. We'll give it a second to clear out. My phone will be next. But anyway, in 1948, they had a big race, and ultimately it was decided by, I think, 32 votes, 62 votes, I don't know, something like that. I don't remember what it was. A very small number of votes that ultimately decided the case. Governor Stevenson had sued in federal court trying to get the results overturned, and Portis, who was in private practice, represented President Johnson at that time. In other words, very close to the president, a very good friend of his, therefore he got nominated to court, and then he was trying to be elevated up to the higher levels. It turns out that while he was teaching at American University, he received a very large stipend. That became kind of an ethical question for him. And also during the hearings, it came out that he was so close to President Johnson that he would go over to the White House frequently and talk to staff about decisions that they were making, and some of the inner goings behind the closed doors of the court. And so ultimately they just said, we're not going to do it. There is a mic on me. Having a hard time hearing me?
Yeah.
All right, I'll try to speak up more. That way I can, is that better? Okay, I'm sorry. So as a result of that, though, ever since then, every justice going before the Supreme Court or being nominated to be on the Supreme Court went through a Senate hearing, and it got to be kind of long. This, by the way, is President Johnson and Mr. Portis talking to each other. You can see how close they were. Remember they used to talk about President Johnson giving the LBJ treatment. You know, that was the way he would kind of lean into people. He was tall, kind of intimidate them. So, picking the justices, they had this filibuster rule that was in place from basically 1917 until just a couple of years ago. And I won't go through the history of that. It's kind of, by the way, I'll be happy to share these slides with anybody. I think Sarah has a copy of the PDF of them. If any of you want to get them by email, and if we need to print some out for you some way or another, I'm sure we can figure out how to make that happen too. But ultimately, what happened was whoever was on the losing side of the court nomination process, in the sense of they felt like if when President Obama was in office, he felt like the Republicans were stymieing his Supreme Court appointments by using the filibuster rule to require 60 votes to get the nomination through rather than just 51. When President Bush was there, it was the same argument. The Democrats were stymieing his Supreme Court votes. So anyway, in 2013, to free things up for President Obama, the Democratic-controlled Senate changed the rule, saying you don't have to have 60 votes; you just have 51 votes to get through any justices, except for Supreme Court justices. So all other federal judges and everything else went through that. And then the Republicans finished the job in 2017 and blew it up for the Supreme Court nominations. I'm going to skip over that one. What's interesting, and here's just a list of some of the beginning of from the end of time today, earlier on, of the justices and what the votes were. If you look and see how close these were, 53 to 47 for Justice Brown, the newest appointee to the court that President Biden put on the court. They were all pretty close for President Trump's nominations, 52 to 48, 50 to 48. President Obama's got a little bit better coverage. President Bush's were pretty more easily confirmed. But it goes on all the way back to the beginning of time. One of President Washington's nominations was actually defeated by the Senate, interestingly enough. But that was his own fault. It was John Rutledge, who was one of the framers of the Constitution, was very involved in the Constitutional Convention, had been a member of the Continental Congress, had been on the Supreme Court before, but had retired. But right as he made his nomination was made by President Washington for the second go around on the court, he went out and spoke against the Jay Treaty, which was a treaty that had been negotiated by John Jay between Britain and France and America. And it was a very controversial one, but President Washington supported it, and the Senate had already ratified it, and he went up and made a big speech against it, said it was the most horrible thing in the world, and we're all becoming, British subjects and so forth. So anyway, they just said, we don't want you anymore. So he didn't get his nomination through, but pass it up. All right, so now currently we have 9 members of the court. The Constitution doesn't say how many members of the court there are to be. It just says there shall be a Supreme Court. So it's up to Congress to decide how many people to put on. And they have since the late 1800s or so, have kept it at 9 members of the court. There's talk from time to time about expanding that, changing it, or whatever else. But for now, that's what it is. The Washington Post once noted, it said the Supreme Court is never going to look like America. Get used to it. Justice Sotomayor said the Supreme Court is never going to be a melting pot reflective of the country. And it's because they require today the justices to be lawyers, to at least have a lot of experience as lawyers, if not be judges, and meaning that they will have had to gone through law school and be kind of at the top of their classes. So they're typically not going to look like it, although they're getting really close on parity between men and women on the court. We now have 5 men and 4 women. We got 2 African Americans on the court, 1 Latino, 1 Italian American, 6 Catholics. The most senior one is Justice Thomas, who's 74 years old, and he's been on the court for 31 years. Justice Jackson, the most junior, only been there for 5 months. Justice Barrett is the youngest at 50. But they all have gone to Ivy League schools, almost all of them, with the exception of Justice Barrett, who went to Notre Dame. So what do they decide? So they get about 65 to 80 cases a year that they decide, and there are about 10,000 requests to the court to hear a case. These cases are mostly questions of law from appeals from lower courts. But occasionally they have some where they have what they call an original jurisdiction, where you got 2 states fighting about something like water or something like that end up there, and they end up being the actual finder of facts and everything else. And generally, the 9 justices don't sit for the trial. They usually appoint a special master, another judge, to go hear the case and then make a report back to them, which they hear and they ratify and so forth. But the court is free to accept or reject any case except original jurisdiction cases, and that's why they end up with 65 to 80 a year rather than 10,000 or so that get up there. And so they can come up from state courts all the way, as long as they've come from the state's highest court, or they can come up through the U.S. Court of Appeals through the federal court system, or they can be, like I said, cases involving foreign diplomat or state government, and they can be original jurisdiction cases. But that's how they all kind of get up there. Usually takes 2 to 5 years for a case to be tried at the lower court level, get through the appellate level, and get up to the Supreme Court. So anyway, if the court has, what they basically do is the people are asking the court to hear the case. And so they're seeking what they call a writ of certiorari, which is basically just an order for the Supreme Court to the lower court to send the record up so that they can consider it and review it. And at the time when someone files a petition with the case, the other side obviously gets an opportunity to file something back to the court, say, no, you shouldn't take the case. There are people out there they call friends of the court folks, amicus curiae folks that get together, and they'll write a brief to the court saying, yes, take it, or no, don't take it. And then if you have one justice who decides that it should be considered, all 9 of them will then sit down and discuss whether or not to take that case. And so how do they get through 10,000 cases to get them all down to 65 to 80? The law clerks do the heavy burden for them. Each justice has about 4 to 6 law clerks that are lawyers that will either together as a group and farm out to individuals to review each of the cases, or there are 2 of the justices now that require their own clerks to read all 10,000 to come through to see what they are. That's a lot of work. So they're very busy in the summertime, especially trying to sort through all that. But anyway, once they get to the conference where the Supreme Court, behind closed doors, by the way, none of this is ever public, where they're discussing whether a case should be considered or not, it takes 4 of the 9 to decide to hear a case. Doesn't take 5, a majority takes 4 to consider it. Get a majority opinion once it's all argued and done and everything else, it takes 5 to get there. Usually what they do on oral arguments is they argue, they set them for 2 arguments a day. Each side gets about half an hour or so. And they start in October. They started this year, Monday, October 3rd. They always started the first Monday of October. And they usually end those cases by the end of April or so. And then they continue writing their opinions, and they try to get them all done by the end of June so they can take the summer off and have a little bit of relaxation, even though they're really not ever fully off. People think about them It's kind of like the president really never has time off. The justices really never have any time off either. They're always out having to do something or hear motions, emergency motions, and so forth. So the oral argument is just a lawyer standing before him at a podium kind of like this, with a couple of lights on the thing telling them when their time's about to expire. And that's it. You got a table about the size of two of these or four of these put together. So we got lawyers on both sides. And then one person is speaking at a time. So you don't have any witnesses because they're just arguing about law. And like I said, it's about 30 minutes per side is how they do it now. And once it's over with, red light shows up on the podium saying their time is done. And unless the Chief Justice extends their time, then they're finished talking. A lot of times they'll get questions right off the bat from the justices as to what they think about a particular line of cases or what they think about particular arguments that are made in it. They're now required to allow them to have a couple of minutes up front to speak. It used to be they'd get about 3 words out and the justice would ask them a question. They've changed the rules where they actually have a couple of minutes to summarize their argument. So they put their big stuff right up front, and then they get prepared for lots of discussions and questions going back and forth. So once the cases are submitted, they all break for lunch. They're done in the morning. They got one here, one set at about 8:30 or 9 or so, and then another one set about 10:30. And once they're done, they all go to lunch. Oddly enough, one of their informal rules is while they're at lunch with each other, and they go to one of the conference rooms, and it's brought up from downstairs. They got a cafeteria down there, brings in their food. They don't talk about the cases. They just talk about what's going on in their lives, how their clerks are working out, everything else. They try to keep it calm and everything else. These folks have to work together for their entirety of the remainder of their professional lives, right? So you might have people who are very, very different. Justice Brown being very, very different in her opinions from Justice Thomas, 180 degrees difference perhaps, but they can be friends outside, and that's oftentimes that they are. Yes, ma'am.
On the oral arguments, they can't really talk about the issues of the case, because that's, I assume, but they can't bring in new evidence. So they're just talking, they're giving maybe other laws supporting their side.
Yes, you're talking about, I mean, they can talk about evidence to a degree, but they can't say the trial court erred in its evidence below, and this is, you need to reconsider the evidence and consider it this way. They're gonna, but so to the extent the evidence is in the record, but the court is bound to follow what the lower court has made a determination of, basically. Almost always. There may be some really extreme cases where they throw it out, but usually that's been done at the appellate court level below. But so yeah, they're just arguing about laws and other precedents, other court cases that might have a bearing on where the judges have decided one way or another on it.
Thank you.
Yeah, you're welcome. Great question. And by the way, anytime, raise your hands if you got questions. Happy to take them. The next week is typically when they all get together and they decide how they're going to vote in a case, or rule in a case, if you will. And the Chief Justice will start asking around the table how each one is going to rule, or what their initial determination is. Are they going to rule for the petitioner, the person who brought the case? Are they going to rule for the respondent, or the person who's arguing against the change from the lower court level? And then the Chief Justice, if the Chief Justice is on the majority side of the 5 of ruling in one particular way or another, then the Chief Justice will assign the person to write the majority opinion. And then the most senior judge on the dissenting side, if there is one, is the person who then decides who's going to write the dissenting opinion. And sometimes you have more than one dissenting opinion. You might have 3 or 4, or you might have one majority opinion and what they have concurring opinions where they say, okay, I concur in the judgment, but this is my take on it. It's a little bit different. And sometimes they can write and concur in part and dissent in part. Sometimes they do that too. Depends. Everyone is a little bit different. Their conference rooms are beautiful in the north. That building is gorgeous. It was built in the 1930s. Cass Gilbert, a very famous architect, designed it. But they meet in these 2 conference rooms, which are these, 50 feet wide and 150 feet long or so, or something like that. And they sit around their tables and they like that, and they
they discuss the cases. They take notes, and each one is given a notepad similar to this, where they've got all 9 justices in a little block, and they can make notes if they care to, as to how each justice was going to rule in a case or what their points were. Sometimes, by the way, after they make when they go to their first conference, they might not have reached a consensus, and then they'll meet again and talk about it some more and try to get that figured out. And just because a justice voted one way in the initial conference doesn't mean they're going to necessarily vote that way when the final opinion comes out. A lot of times they'll shop the opinions around and say, hey, can I get you to join the majority if I use this argument, or if I take this argument out, something like that. It's an interesting, the thing is, we don't really know what goes in it because it's just the 9 justices. They don't even have their clerks with them while they're going through all this. It's just them. So you got to rely on what they might say at the end. Once they've decided how they're going to do it, the person who's got the job to write the majority opinion, the one who's got the job to write the dissenting opinion or opinions, generally they ask their law clerks to take a first stab at a draft, then they review it. They're comfortable with it, the justice is, then they send it out to the other justices for them to review and to get their comments. And interesting that they send back letters back and forth. I apologize for my watch. Let me fix that. Maybe. But they send letters back and forth to each other, formal letters saying, dear Clarence, I like this opinion, but I think you should change this, this, and this. Or dear Clarence, if you don't change this, this, and this, I'm going to switch sides and I'm going to dissent. These things like that. Or I think you should consider this particular case in your line of arguments and those sorts of things. And they work it all out between them and the clerks. And it sometimes takes a while.
I was going to say, what's the average time that they spend per case discussing back and forth and writing the notes and that sort of thing?
In conference themselves, they typically, when they're in a conference day, they're there all day. And sometimes they'll do lunch breaks, or sometimes they'll finish up early. And it depends on how many things they've got in their conference, because at those conferences, they're also, depending on the time frame in the year, sometimes they're also discussing whether to take another case or that sort of a thing. So it depends on what's on there. So I don't know that I can tell you how long on average.
Juggling several things.
Yeah, they are. They are. Yes, ma'am.
Are the clerks, they're not in the conference room with them?
They are not in there with
They're
them.
not in there.
It's just the
Yet
justices.
they have to write the first
They
draft.
still have to write the first draft. But the clerks, keep this in mind, the clerks have all, because they have read the 10,000 opinions, I mean, a request to start with. Now that's going to be just very perfunctory. But prior to the time in which the case gets up to oral argument, each side has filed what they call a brief, which is, 100 pages of lawyer talk per case or so. Each side has filed a brief. They've also filed a reply brief for the other side. The amicus people, the friends of the court people have filed, their stuff. So it's been pretty well fleshed out as far as what the law is and everything else. And they've also had a discussion with their bosses about what their bosses think about a particular case. So they kind of know where it's coming from. And then the boss will sit down after the conference and say, okay, I want you to write a majority opinion on this case, and I want you to put the following points in. And then that's how they do that. And each justice also has a different take on how much of the clerk's opinion they're going to take. A lot of times they will just cut and paste things together that they've done now. Back in the old days, I don't know how they did that. It was a little bit more difficult. The true cutting and pasting was probably true cutting and pasting. I remember those days from when I worked at the legislature where we would actually literally cut and paste things together. It was messy, but it worked. But each one uses things a little bit different. Some will take everything, some will take just some of it. The last justice to have written everything from scratch was Justice Stevens, who just passed away a couple of years ago, but he retired maybe 20 years ago or so. But he would actually take his own opinions and start from the beginning and work through. Yes, sir.
Can a justice abstain from making a decision?
Yes, and sometimes they have to if they have somehow been involved in that case or have some sort of a personal interest in the case. Justice Kagan, as an example, recused herself, is what the formal word they use is recused themselves. She recused herself from a number of the cases that she had argued before the court as a Solicitor General on behalf of the U.S. government. And sometimes, so they will do that. But that's about it. The judicial canons require judges to not shirk their duties, if you will. So if it's like a really sticky opinion, like one of the abortion opinions or the LGBTQ opinions and those sorts of things that come out where they might not want to necessarily go out on a limb on a point, unless they have a personal reason for not being involved, they typically are required to do so. Now, I don't know if anyone has ever said, I'm not going to write on this. I don't know. That's a good question. I've never seen that, but I could see perhaps past long time ago, perhaps so. But good question. So opinions do change sometimes significantly from where they started out in conference or where they started out from the initial draft that was sent out. We'll talk about the leaked draft of the abortion opinion here in a little while, but sometimes they change a little bit from that. But after all of them have decided for sure, once those drafts have been circulated around, what majority opinions they're going to join to, or what dissenting opinion they're going to join to, or whether they're going to write their own. Once everyone's decided where they're going to go to, and they have submitted them, then the opinions themselves are the case is finalized. The Chief Justice's staff will then set a time in which the Associate Justice will make their ruling from the bench, if you will, when they all get together. They're generally read at the beginning of the court session after they do a couple other housekeeping business. In reverse order seniority from the justice writing the majority opinion. Sometimes the sitting justice might feel strongly enough to read their whole dissent. It's rare, but sometimes they'll do that. Justice Ginsburg used to do that from time to time. Very rarely do they issue any concurrences. This is a graph. It's kind of hard to read from the back, but what it shows from the beginning of the Supreme Court from the early 1800s through 2022, how many opinions were unanimous. And if you look at the top and left, almost all of them were unanimous in the very early years of the court. They all agreed what it was going to be. And we got very disagreeable back in the 1950s and have remained disagreeable since then, more or less. Yes, sir.
On the left there, what's the one, or there's a disagreement, I can't read it from here. Well, a couple inches from the left, and it's the one where it spikes down.
Yeah, spikes way down. Let me look and see, get a little closer to this, what year that was. You know, I don't know what that, it looked like it was like 1836, about the time Texas became a state of the Union.
And where's the Dred Scott opinion, 1850? Down?
Right.
Where is that?
It'll be just to the right of that. You know, it was still, you could tell it was still a difficult time. So that probably would have been that next lowest one, just to the right of that, is probably been what that was. That'd be my guess. The Dred Scott opinion was the horribly racist opinion that came out in the 1850s. It essentially said that African American people, Black people, don't have the same rights as everybody else. But yeah, I don't know. That's a great question. I'm gonna have to go back and research, figure out what happened in 1836. Because I don't know. Anyone, history scholars in here that I can remember? Okay, I don't recall. Dr. Allen's out there. I know she's a history scholar, but. So there are all kinds of different approaches to interpretation that the judges make and have made through the years, and they morph over time. And by the way, they can use any combination of these or their own home-cooked versions of interpretation of the Constitution or the laws in writing their opinions. But the broad categories are some of the ones that I kind of got to go through. Textualism is the one where they focus on the actual plain meaning of the Constitution or the statute that they're looking at. What does it say? Okay, let's follow that. That's kind of in many rules, you know, like contract rules. That's one of the things that typically the courts will do. All the courts will say, what does it actually say? What do the words mean? And then they try to figure it out from there. Then if something's ambiguous from there, then they kind of go out and they try to find other ways to explain what it is by looking at history and so forth. Also, they try to look at what the terms in the Constitution, when they're looking at the Constitution, is how it was understood by the people at the time they were ratified, in the context in which the terms appear in the Constitution. They usually don't consider the practical consequences of the decision. They just said the text says this. A few years ago, Justice Kagan spoke, and she basically said, we're all textualists. Now, I mean, we all look at what the Constitution says, and we all try to follow it. It's just, we might reach different conclusions as to what it might mean. Originalism is something that kind of came about in the 1980s. I didn't mention Justice Bork, but he was on one of my slides earlier. He was a kind of a constitutional scholar and a judge on the District of Columbia Court of Appeals that President Reagan put up, but was defeated in the U.S. Senate. He was one of the founding proponents of what originalism meant, meaning that you should go back and look at the time that the Constitution was passed or the law was passed and determine what the intent was based upon that and what the meanings of the words were. Justice Scalia, who passed away a few years ago, was one of the people that kind of carried that forward. Justice Thomas kind of continues that as well. Pragmatism is kind of what people who are more moderate, I suppose, in their judicial philosophies will do, the way the balances of the practical consequences of one interpretation of the other, kind of different from the textualism was. One will weigh cost and benefits of how things should play out. Another one looks as how the court could consider how the judiciary could play a constructive role in deciding a question of constitutional law. All of them, in some form or another, believe in following prior precedent, although they will occasionally overturn things. Like they overturned the Dred Scott case. They overturned Roe versus Wade, the abortion case that was decided in 1972. They did that last year. But in general, they try to follow what their prior precedent was, unless they find a specific reason or a number of reasons by which they think it should be overturned. Idea behind that is there should be some continuity, right? Some expectations that people have as to what the law means, that sort of a thing. So all 9 justices today and in recent history would all, I think, argue that you should follow stare decisis or the prior precedent when you can. But then sometimes they might find reasons not to do so. Sometimes they use a moral reasoning where they look at concepts or ideals that underlie terms of the Constitution. What does it really mean? The idea that's kind of the Roe versus Wade concept came out of that, the abortion case, where they looked at the justices when they wrote the opinion. But well, okay, there's all kinds of different rights of privacy pieces of it that are in the Constitution itself. Therefore, that's what the moral reasoning is. So therefore, we should find a right to privacy for, the right of abortion, that sort of a thing. Time to look at national identity or ethos. We look at the distinct characters of the American values and those sorts of things. Structuralism sometimes comes into play where they're trying to decide, and especially looking at separation of powers between the 3 branches of government and the relationship. Historical practices. I don't know, you see a whole lot of that in the Supreme Court, but what has the federal government done? What have the states done over the years? And are we going to overturn something significant? And is that a good thing or not? And it kind of goes back, that stare decisis thing is the gay marriage case that came out a few years ago. One of the arguments is that Justice Thomas made in the abortion case this time was that perhaps they should look at that case again and maybe some of the other cases. But I think a lot of the justices, and they wrote about it in the Dobbs case, saying, no, we don't want to go back and look at that again, because historically we've had a bunch of people get married and relied upon the federal government's assurances that it's a right, and therefore we really shouldn't go back and do that. One of the newest things on the new kid on the block, I guess, is what is called this common good constitutionalism. No one on the court at this point in time, to my knowledge, actually kind of follows this, but there's a law professor at Harvard, Adrian Vermeule, who is kind of proposing this, and he's saying, look, so it's somewhat kind of like the moralism argument that we talked about a moment ago. But he said laws should not be tied to particular written instruments of the law. but instead look at rational determinations of the common good. What's the common good? How should that be applied? How should that work? And he thinks originalism should go by the wayside because it is so subject to interpretation as what people thought in 1789 or something similar to that. All right, switching gears a bit. Let's talk about the different justices. Our Chief Justice is John Roberts, who was appointed by President George W. Bush in 2005, and kind of gone through their different faiths and where they got their degrees, so I'll kind of skip over that. But he's basically conservative, but he's also a bit of a pragmatist. One of the things he tries to do on the court as Chief Justice is get as many of these opinions out that are unanimous or close to unanimous as they can be. He tries not to upset the apple cart on things. In the abortion case, he wasn't said to have been in the initial majority of what the court did in the Dobbs case in overturning Roe v. Wade, but he changed his opinion, I think, once the leak occurred. But he's always trying to try not to upset things and he's got this idea that the Supreme Court is a grand institution, which I agree with, of course, but it shouldn't be politicized, and therefore he goes out of his way not to politicize things. And sometimes as he goes so far out of the way not to politicize things, he might politicize things by doing that. But that's kind of his thoughts.
Question,
Yes, sir.
your voice trailed off.
Yes,
You said
sorry.
he changed his opinion, I didn't catch
Oh,
it.
in the Dobbs case, on the abortion case, when the initial leak came out to Politico, with a news magazine for politics and courts, actually just online, I don't think they even print anything anymore, but he was not said to be in the majority. That they thought they had 5 justices in the majority. He was one of the dissenters, thinking that no, the court shouldn't overturn Roe v. Wade. We should just nibble around it a little bit more. But he, if this is true, and I don't know, he may have been part of it. He may have been part of the majority at that time. He might have already been up at 6. But the thought was that because he felt like the court was trying to be swayed by the leak, that he therefore then joined with the majority to say, I can't be swayed.
Was there any reaction, was it Kansas, where a month or two after the Dobbs decision came out, there was a vote on abortion versus anti-abortion?
Yes.
And a substantial loss for abortion rights,
For
anti-abortion.
yeah, for abortion restrictions, yeah.
Any justice never make any comments on that?
No, I've not heard them make any comments on that. Good question, but I have not. Sarah?
Question for the people.
Oh, sure. Yeah, I'd be happy to. Gentleman was asking, after the Dobbs opinion came out, reversing Roe versus Wade, there was a vote in Kansas to, I guess, enshrine in the Constitution, if I recall it, the state constitution, some restrictions on abortion. And it was fairly resoundingly defeated by the electorate in Kansas at that time. And the question was, have any of the justices commented on that? And that not to my knowledge. That's one of the things they try not to do. It's one of the reasons you don't read much about them or hear much about them. They try not to make news, more or less. They like to fly under the radar. Justice Thomas is the senior associate justice on the court. President George H.W. Bush, the Bush 41 versus Bush 43, the first Bush, appointed him in 1991. And his philosophy is he's very conservative. He's an originalist, probably most closely aligned with Justice Alito on the court. And he's often an outlier on opinions that come out. And he's kind of like if there's an 8-to-1 case, he's often the one that's out there kind of on his own merits. Justice Alito, President George W. Bush 43 appointed him. He's, like I said, very closely aligned, I think, with Justice Thomas. He's philosophically conservative. He's an originalist, also a textualist type justice. Justice Sotomayor, appointed by President Obama in 2009. She has sort of a pragmatist type of viewpoints on things, doesn't often tie things necessarily to the laws or the Constitution, but does, in a sense, maybe the common good originalism that Professor Vermeule is proposing kind of follows that. But I think even when you follow a common good, or you follow an originalist, or you follow a textualist approach, it's your own philosophy on what the law should be and how it should be that actually comes into play. Just because you're an originalist or a textualist doesn't necessarily mean you're a conservative, because someone on the more liberal spectrum can actually use textualist and originalist arguments as well. But that's typically where she comes down from. Justice Kagan, also appointed by President Obama, philosophically liberal. She's a textualist. She's more moderate in her rulings, I think, than Sotomayor and Justice Jackson will be. We don't know for sure about Justice Jackson because she's so new, but we will see. And the interesting story about her was when the nomination came open, or the position came open, Justice Scalia told the president at the time, he said, I don't care who you put on the court, but please put someone on there with a lot of intelligence, someone like Elena Kagan. And they disagreed a lot on things and policies, but they also respected each other very much. Told a story during the preview of this course at one point about Justice Scalia and Justice Ginsburg. Very, very polar opposites in their philosophies on things, and very rarely ruled together when there was a dissent on the case. But they were the best of friends. They traveled together. They rode elephants together in India. They went to the opera together. Not only did they go to the opera, but they dressed up in period costumes for operas. A little unusual, but they would do that. A day after Justice Ginsburg's husband Marty passed away, she was reading a majority opinion on the bench, and she was holding her own, just reading through it, just as if nothing had happened. And Scalia was just bawling. I mean, he couldn't, he felt so bad for her. Anyway, like I said, they have to practice together, live together, work together, not live, but work together for the rest of their lives. In the early years, they did live together. They often stayed at same rooming houses and so forth, but now they're kind of wherever. Justice Gorsuch, President Trump's first appointee in 2017, philosophically conservative, libertarian leaning, kind of a textualist, but he's the guy who wrote the opinion in the Boston County case, in the Clayton case, which added gays, lesbians, and transgender folks to the Federal Civil Rights Act. So you would think a Trump appointee would not be quite so liberal or moderate, but he used a textualist approach and came up with that determination. Justice Kavanaugh, I don't remember how much controversy he had when entering his nomination. But he's a conservative textualist, originalist, but he's also kind of a pragmatist and kind of follows along with Chief Justice Roberts. They kind of most frequently go together. Justice Barrett, President Trump's last appointee, succeeded Justice Ginsburg. She's a conservative, originalist, textualist. Don't know a whole lot about her yet. I mean, she's had 1 year on the court, but we'll see as she goes a little bit more. And likewise, we don't know much about Justice Jackson's rulings. She was on the District of Columbia Court of Appeals for quite a while, or a couple of years, but didn't issue a whole lot of opinions. But they believe that she will be, the scholars of the court and so forth, she's going to be, kind of liberal, obviously, and going to follow along the lines, perhaps, as what Justice Breyer did, whom she replaced. In the last term of the court, OT means October term. That's for the shorthand for it. Each term starts in October. So 2021, last year's term before 2022. These are how the justices kind of ruled together or wrote together on things as far as being in the majority. But in Roberts and Kavanaugh, you see we're very close at 95%, Barrett 90%, Alito at 85%, and so forth. Justice Sotomayor being on the least on the bottom. Okay, let's talk about the leak for a little bit more. We kind of touched on it a little bit, but those things are very rare. So, they do everything behind closed doors. In general, justices don't speak at all about what happened behind the doors, except maybe with their clerks, or in the case of Justice Fortas, maybe to President Johnson. But as a general rule, they don't do that. And so it was a very upsetting thing to the Supreme Court that this got out, because they felt as if it was someone that was trying to sway the opinion of the court, because it was only the original opinion, the first one that goes around, that they route around and the justices look at it and so forth. Oddly enough, when they issued the final opinion a little over a month later, it was very similar to the original one. The only changes were changes that addressed some of the concurring opinion language in there that people wrote. Some changes that I mentioned before that Justice Thomas had mentioned about perhaps we should look at the gay marriage cases and some of these other things. Justice Alito specifically wrote and changed things to say, no, we shouldn't. But those were the different things that were all done on that. But there was speculation, as I said, that it was to sway the final opinion. Conservatives thought it was to sway it to get someone to flake off, and the liberals thought it was a way to get people to flake on. So kind of depended where it was. So the Chief Justice appointed or nominated or whatever Gail Curley, who's the marshal of the court, to be the chief investigator. I don't know how that's going. They had said they thought they would have something by early fall or so, like a who did it or some sort of report on it, but they haven't done that yet. The marshal of the court, while she heads up the Supreme Court Police Department, she doesn't really have much by way of subpoena power or anything such as that. So they just have to lean on people to give them the information that they want. But we'll see how it goes. And she doesn't have a law enforcement background. She was adjutant general in the U.S. Army, a colonel in the Army. So we'll see how it goes. But Roberts said it was absolutely appalling. Justice Kagan said it was horrible and terrible, blatant violation of the court's rules. Justice Thomas said it was like an infidelity. Justice Alito said it was a grave betrayal of trust, and it gave people a rational reason to think if they could prevent the ruling from happening, perhaps they might kill one of us. And there was a guy that was arrested, attempted assassination of Justice Kavanaugh. So who knows? So about 70 people had access to that opinion. And from the 9 justices to their 4 law clerks each, to the print shop employees and so forth. So I'm sure each one of those has been grilled. And I'm not sure what we're going to come out of that. The shadow docket. You hear a little bit more about this from time to time. This is a law professor coined the term. It occurs when a case goes up to the Supreme Court that hasn't been final. Almost, the only cases they usually take are finalized cases that have gone through a trial and everything else. But sometimes, like it's an immigration issue. We had a bunch of those during the Trump years, and we've had some of those during the Biden years, where someone has said, look, the Trump administration didn't follow the Administrative Procedure Act in adopting this rule. And so therefore, the court needs to say the rule has no applicability. And so they asked the Supreme Court ultimately to enter basically an injunction against the enforcement of the rule. That's a shadow docket where the cases kind of go up. So you get a bit of a preview of what the court might think on a particular issue, but you don't know for sure how they feel on the whole thing as to how they rule on that little minor point. And they call a shadow docket because typically there's not oral arguments in the case. Everything is not fully briefed and everything else. So that's it. I mentioned before the court started working on October 3rd in session amongst the people, opened back up first time in a couple of years to everybody being able to go in and watch the court, although it's still a very socially distanced group up there. And I think that, they're in a it's a large room, but they're in a one large courtroom together. The average age of the justice is something like 72 or something like that. And so I think they were concerned about COVID. So they did a lot of oral arguments and so forth from Zoom for a while. And then they brought the people back, but just the lawyers could come back in last term. This term, they're letting the lawyers and some people back in the courtroom. But in reality, the courtroom only seats, a couple hundred folks at a time anyway. So it's not like a lot of people are doing it. One side benefit that's come out of this is you can actually listen, and I've got a link on here. You can actually listen to the court arguments live now, which is something that didn't happen before COVID. That's kind of cool. You used to have to wait until the Friday after the case was done and they would send it out. So now you can actually listen to it full time and see how they go. So here's a few of the cases that are up. We've got some admissions cases on use of race in the admission process in colleges. One is at Harvard, the other one's at the University of North Carolina, several different things. The cases are a little bit different, but they heard them at the same time, or going to hear them at the same time. No, they heard them on Halloween. 20 years or so ago, in another case, Justice Sandra Day O'Connor, sorry, just went blank for a second, wrote a case called Grutter versus Vollinger. And in that case, she said, okay, yeah, the Constitution says everything should be race neutral, but we're still trying to fix things from prior times in which everybody was discriminated against, even though the Constitution back in those days also said everything is race neutral. So we think maybe in another 20 years or so, we can come back and revisit this case, but for now, it's okay for the colleges to consider race, not use it as a sole determinant, but use race as one of the factors in determination. So 20 years have passed, and of course, the cases have bubbled back up to the court, and so they're looking at that again. So that's what they got a group of Asian students saying, because I'm Asian, I'm discriminated against because my grades are better, my scores are better. I should be in college, but people whose scores and grades are not as good as mine just because they look different from me are getting in. That's wrong. So that's kind of the basis of a lot of these. National Pork Producers Council versus Ross. Our friends over in California, through a proposition, basically outlawed practices that were used in confined animal feeding operations, where these large corporate farms where they would put bunches of pigs or bunches of chickens or whatever it is together and feed them and so forth, and cows. They're saying, no, you got to give them space. You got to do other things such as that. So because there's a large agricultural industry in California, California's regulation of how things are raised and fed and processed affects the rest of the country. And so they're questioning whether or not there's some sort of an interstate commerce violation that the California law violates. Let's see how that goes on. Andy Warhol Foundation versus Goldsmith. Goldsmith was a photographer. He took this original picture. This is not the original picture. This is the Warhol doctor up of it. But he took a picture of Prince back when he was alive, the artist or the musician. And he actually licensed it to Warhol to do something with it. I don't remember what it was. It's a very, very specific project. But Warhol then took it and then continued to sell the image as his own, changed a few little things in it. So the question is, to what extent of the copyright law did Warhol change things enough to have his own work of art, and he did not infringe upon Mr. Goldsmith's photograph or not? We'll decide that. U.S. versus Texas. I mentioned before how we have these things in the shadow docket. This was kind of one of those cases in reverse, but during the Trump years, there were a bunch of cases in which the courts overturned Trump's actions on immigration and some things because they said they didn't follow the Administrative Procedure Act and got notice and comment and publishing the draft rules and 30 days extensions and those sorts of things. They didn't do that, just issued out a proclamation saying this is the way it's going to be. Biden did the same thing. So, kind of reversing some of Trump's stuff and then saying this is how we're going to prioritize the deportations in the country. And so it's coming up from a Texas court saying it's illegal. If Trump's stuff was illegal, then Biden's stuff's illegal. Everybody's got to follow the same rules. So that's where this is. I don't know what they're going to come up with. One of the big questions is whether or not a state, Texas and Louisiana sued in this particular case, whether a state has standing to challenge the federal rules. And then if so, then are the guidelines contrary to the Administrative Procedure Act? The court may just say states can't do it, case dismissed, and then you don't get a final ruling on the other issues. Let's see. You remember the Colorado bakers case a couple of years ago where the guy didn't want to bake wedding cakes for gay couples for their marriages. Same law, same state, but here it's a web designer, and they didn't want to design a website for a gay couple that were getting married, and so they filed their thing there. The cake shop case, the Masterpiece Cake Shop case, was decided because they found some animus, court did, in what the Colorado Commission did that was specific against the the Baker, and they thought that was a way to overturn or to overturn what the Colorado had done to the Baker. In this case, I don't know that you got that again. So they're coming up, they're now having to face the full issue again. We'll see if they can decide it and avoid it or not. Moore versus Harper. The Constitution says the state legislature shall decide the time, place, and manner of elections and so forth. So the question is whether that means the courts in those states, whether or not they had the ability to go in and change what the legislature did and apply their own plans. So in this case, in North Carolina, the legislature, controlled by the Republicans at the time, passed a redistricting plan for members of Congress and legislature. And the Democrats filed suit, and then they overturned it in the court, and the court drew its own lines. So the question is, what can a court do that or not? Let's see what they end up saying with that. There's two cases: Gonzalez versus Google and Twitter versus Tamina. A little bit different facts, but both similar in that can a social media company or a search engine company be held liable for terroristic acts? How far must they go in policing what other people post or say? And this will be an interesting one to see how things go. Those two. This one's kind of fun. Jack Daniel Properties versus VIP Products. The company has developed a dog chew toy called Bad Spaniels. And it looks very much like a Jack Daniel's whiskey bottle. And so Jack Daniel's people sued him and said, "You can't do that. You're infringing on our copyright." Like, it's a dog chew toy. It doesn't say Jack Daniel's. It's not whiskey. No one's going to be confused. So we'll see what the Supreme Court says on that one. And here, like I said, we'll get Sarah to get the information to y'all. But here's some websites if y'all want to learn more about different things. There's some books you can read and so forth. But anyway, I'm open for questions. Yes, ma'am.
You know, when they're going before the Senate, for confirmation hearings, you know, they're used too liberal or they're too conservative. And I wonder if I'm naive or altruistic thinking that they would do the right thing as far as looking at the law. Would you venture an opinion?
Yeah, I would say that all 9 justices on the court and almost all of them leading up into them would say that's all they do, is we just look at the law and the way it's presented to us. Chief Justice Roberts famously said during his confirmation hearing that he only looked at balls and strikes and called them. And he didn't, would go anything further than that. And to a degree, he's been that way, but he leans conservative and that sort of thing. So I don't know that any of them actually go in and say, I've got this idea for the way the country should look, and I'm going to be sure that all of my opinions get us there. But I think that they all try to do the right thing. It's just, they just look at the world differently.
Mm-hmm. Thank you.
Yeah, you're welcome. Yes, sir.
How much would you have to contribute, 10, 20, $30,000 in order to join the Supreme Court Historic Society?
I'm a member of it.
Are you really?
Yeah.
How much did you contribute?
I think it was $150. I can't remember, but it wasn't a vast amount.
Didn't somebody, Blake Johnson, his name, he contributed like 25,000?
Maybe.
Was that in the news?
I don't know who.
So?
I don't know who.
Blake Johnson, was that his name? And that's where the allegation of legal may have leaked the Roe case.
Oh, yeah. I don't know. But I don't think the Historical Society, technically the Chief Justice sits at the head of it, but it's really more of an advisory role. I mean, really, they hold lectures, and each justice sponsors a lecture during the term, and people go to the courtroom and Supreme Court room and have dinner, and then they do that. So I don't know.
Have you been?
Yeah, I have, and they're great. I mean, the talks are always really interesting, and it's unusual to get to go into the courtroom, but they still have the same rules if you're either observing or you're at one of those things, or if you're up on the bar at the front arguing.
Do they have a building across the street in the U.S. Supreme Court?
Say it again.
Do they have a building, the Supreme Court Historic Society?
Right across the street.
Across the street.
They're about a block away or so. Yeah. the John Rutledge house. Remember John Rutledge I mentioned before? His house is the Historical Society's headquarters. But I was gonna say that they have the same rules. I mean, you can't take your cameras in, you can't take your phones in, you gotta, do all that kind of stuff. The case that I was involved in, I didn't get to argue it, but I got to sit at the council table and pass notes, which was a lot of fun. But they would give you about a 20-minute lecture, the marshal would, before you went in there, about the different things you should not do. You cannot chew gum. You can't, you can't, whatever it is. And the marshal would wear a formal morning suit, had big pockets in the front, and had cough drops in there. Anyway, in the middle of one of those arguments, I was coughing and came by and me tapping on the shoulder, gave me a cough drop. Yes, sir.
We've heard a lot about expanding the Supreme Court. What is the procedure for that to happen?
It would just take an act of Congress and the president to sign it. Both houses, majority of the House, majority of the Senate, just a regular bill going through to do that. There's been talk about whether they can change the terms and say, you can only serve 20 years, or you have an age limit at age 70, you got to retire. Not sure they can do that constitutionally. And interestingly enough, who's going to decide that? It's going to be the 9 members of the court it goes up to, but yeah, that's how that would work. So if they wanted to expand it to 13 or something similar to that, that's how they would do it. So it'd be the House or the Senate would start the bill, or both sides would start it and pass it and go to Congress.
The House has changed now, huh?
Yeah. Yeah, you got a Republican House, so they're not likely to change the court at this particular point in time. Everybody else? Sarah, do we have any from online? Oh, good.
I
Yeah,
just curious, nosy. You live here in Austin County, is that right? In Douglas County?
I used to. I live in Burnett County now, just one county over.
Okay, and you teach at Texas Tech University.
Yes,
Is that a far piece?
it's a far piece, but we have a campus in Marble Falls.
Oh, really?
And although most of the students there that I teach are in Lubbock or elsewhere, because we teach them via Zoom, but we have live students, like Sarah was a live student, that from the local area that can come in and take the classes. We did it. Ken Hance, who is a former state senator, former congressman, former railroad commissioner, I don't know what all he did, a lot of things, but he became chancellor at Texas Tech University. He was very politically savvy, and he said, what we need to do is put a campus in every one of the 31 state senators' districts, so that they'll all be want to help us in funding. He retired before he was able to get there, but he got a bunch of them done. Marble Falls is one of those.
Does UT Austin know this, that their Texas Tech is here?
I suspect so.
I wanted to ask about how states sue the federal government. You said that was one of the things, and we hear all the time that the Attorney General is filing suits again. He said, I wake up in the morning and I sue the government.
Right.
So what happens to all of those things? Because they obviously, if there are that many, they must be irrelevant in many cases.
Some are. And what's interesting, all the states do it, but the larger states have better funding and they tend to do more of it. Texas typically, files from the Republican angle. California typically files from the Democratic angle. But yeah, the cases get filed and they, as all good lawyers do, they forum shop. They try to find the courts that's going to be a little bit more favorable to them. And then they go there. But you're right, you don't hear a lot about what actually happens. You get the headlines saying, Paxton announces today that he sued the Biden administration 12 times to do whatever. But you don't see a whole lot of returns of it. But ultimately, they either get decided on merits, or what they sued over changes and then it becomes moot, that sort of thing.
How much filtering is done before it reaches a point where it is literally considered?
Just like any other case. I mean, they'll file their motions to the court saying, look, there's not a case of controversy here. I'm talking about the trial court. Therefore, it should be dismissed, or should be dismissed as a matter of law. They do like what they call a summary judgment, and they rule on it that way. And then it goes up to the appellate level and they do that. But that's just like anything else. And sometimes they take evidence on things and consider them. Anybody else?
have one for Zoom.
Okay,
How does Trump case seem to surface for the justice's review right away?
say that one more time. How does Trump?
How does Trump's case seem to surface for the justice's review right away?
Maybe they're talking about the tax return case. Perhaps,
But also the special master down in Florida.
yeah. There's that one too for the documents. And I don't know how all of that's ultimately going to get figured out. The tax case is over because the tax returns, because basically the IRS has turned those over to the House committee. And we don't know how anyone ruled on that. It was a unanimous ruling or no one dissented from it because it was just a minute order that came out from the court. As far as the one out of Florida, it's pending in the Court of Appeals, and I don't know what they're ultimately going to do with that either, but I would expect it ultimately to end up at the Supreme Court, at least asking them from them to weigh in. A lot of people would say that the justices that Trump appointed should therefore not rule on anything that he did. But as long as they weren't involved in the administration when he did things that or involved in him privately in which he did things, it's not at all uncommon for a Supreme Court justice to rule on matters from the same administration from which they were appointed.
I asked that question
Okay.
because but because you talked about how long the process is of many of these.
All right. Well, thank you all very much. Probably welcome. I don't know if my email address is on there, but y'all can always check with Sarah if anything else comes up. If you have any questions, let us know. It's been a pleasure. Yes, sir.
Did you ever happen to know Byron Fullerton when he was at Tech?
I did. Yeah.
You knew him personally?
Yeah.
He was a very good friend of mine.
Oh, really?
He came here to Austin, of course.
Yeah.
I have one of his paintings in my house.
Really? Wow.
He's a great guy.
Yeah, he was. He was. Yeah.
I'll tell you a really funny story about him. I used to have lunch with him about once a month. And at his favorite place, which was a bowling alley. And he was going
The
with.
Dart Bowl?
Huh?
The Dart Bowl, is that what it was?
I believe it
In
was.
Austin, yeah.
He was going with another woman who lost her husband. They traveled together and so forth. We stayed in a lot of